Good afternoon, and thank you for joining us. This webinar is being recorded, and you will be able to view it on Standpoint's YouTube page. The link to the recording will also be emailed out to Standpoint's Legal Advocates listserv after the webinar. My name is Nikki Kelly. My role today is to help facilitate the webinar. If you have questions during the presentation, please type your question into the Q&A, and the presenters today will be responsible for checking that, since I will be giving them their PowerPoint. So they will be answering their questions. Most of you probably know about our organization already, but for those that listen to this later and those that don't know, Standpoint is a statewide organization. We're a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to system professionals who work with survivors. We do this by facilitating trainings and answering calls to our action line. Examples of trainings we do are the annual new laws throughout the state of Minnesota, monthly webinars for advocates, and other trainings by request. Our action line is answered Monday through Friday from 9 a.m. to 4 p.m. And it's through our action line that our attorneys provide legal advice to survivors, and our advocates connect with callers with resources, safety plan, listen, and help callers identify possible options and next steps. Personally, I'm so excited for today's webinar. Our presenters today are Megan Mays and Beth Ossel. Megan has spent the past 10 years representing families in court who are involved in custody and parenting time disputes, securing the return of children taken out of the state, and enhancing safety for victims and their families. Megan is the co-author of the Civil Remedies for Survivors Manual, available to advocates, and continues to find innovative and effective legal strategies representing families. Megan practices out of Mankato, representing families throughout southern Minnesota. Outside of work, Megan enjoys hiking, playing music, and travel. We also have Beth joining us. She's a member of Standpoint's team as a staff attorney in October 2020. Beth graduated from law school at Hamline University and directly after graduation clerked in juvenile court in Hennepin County. Most recently, she worked as a staff attorney at Central Minnesota Legal Services for 6 years. At SMRLS, Beth provided direct representation and legal advice in the fields of family law, orders for protection, harassment restraining orders, and criminal expungement. She also partnered with the Domestic Abuse Service Center to represent victims of sexual and domestic violence and strengthen the capacity of advocates working in these fields. Beth previously worked as a full-time volunteer with Lutheran Volunteer Corps and AmeriCorps, and brings to Standpoint a lifelong passion for advocacy and helping others. So without further fanfare, I'm going to hand this over to Megan and Beth.
Thank you, Nikki, so much. I appreciate it.
Thank the intro.
Yeah. I think as soon as we pull the the old PowerPoint up, I can get started. All right, Nikki, do you mind moving on to the next slide, our training goals? Okay, so today's webinar is entitled Give Me Back My Kids. Thanks so much again to Megan for joining us. It's always fun when we can have guest presenters who are experts in this area. So I think before we dive in, it's good maybe to establish our training goals, what we're hoping to accomplish today. So since this training is about you as advocates working with your callers and your clients to help retrieve their kids, get their kids back into their custody, our first goal is to help them identify the rights and responsibilities of parents with regards to their children. Because before you can enforce someone's rights, you have to know exactly what they are, who has custody, if there's a parenting time schedule, things like that. We're also planning on going through a wide variety of options to help resolve these disputes that arise when a custodial parent cannot regain custody of their children. These options include proceeding both with and without court intervention, and both identifying these options and helping you identify the best path for your client to proceed. And then last, our goal is to assist you in learning how to draft pleadings for an action called a declaratory judgment. So that is one of the options that we are going to go into detail about. One of the options that is available out there to help your client retrieve their children when they're no longer in their custody. So we'll go into this in a lot more detail in the end, but we have provided you with a packet of forms that are meant to aid you in helping a custodial parent file for the civil action called the Declaratory Judgment. Much more about this later, but in short, this is a court action not to establish custody and parenting time like you do in family court, but instead asking the court to issue an order simply declaring what is already true in many cases, that an unmarried mother has sole custody pursuant to Minnesota statute. And so the goal of this is to aid in the common problem we're seeing, that for some out there, if they don't see a court order, it doesn't exist. As it exists now, there are no statewide forms available for an unmarried mother to ask a court to declare their sole custody status. So we're hoping to provide another. Yes. This is first step. So we're attempting to provide another solution to this issue, which between Standpoint and SMRLS, we can tell you it's widespread across the state. Anything else on these goals, Megan, before we move more into kind of our overview of kind of what the problem is that we're seeing?
No, I must say though that I did snoop on the guest list and I recognize a lot of you guys. So I just wanted to say hi and thanks for coming. This is such a passion project for me. So I'm incredibly stoked to be here today.
And we are stoked to have you. All right, Nikki, I think we're ready for the next slide. Just kind of an overview of, those were our training goals. This is our overview of what we're hoping to accomplish today. So again, with the next slide, we're going to go into a little more introduction into both how you can tell who has custody and also more introduction into the problem that we're seeing that we're hoping to address today. Again, namely that custodial parents often do not have an effective option in place to secure the return of their children when they've been removed by the other parent and that parent refuses to give them back to the custodial parent. Next order of business would be moving on to options that you can help your clients with if there is already court-ordered parenting time. So those are actions that you can file within an existing court order or ways to enforce that existing court order. Third is maybe the most common problem I see that kind of falls within this realm is what to do if there is no court-ordered parenting time. So these are some tools that you as advocates or attorneys, whoever's watching today, can use when you're working with law enforcement, for example, to try and seek the return of children, and also a discussion of possible court orders that your clients can obtain. So that includes that discussion of this declaratory judgment packet that we're introducing today. And then part 4, it's kind of our last ditch effort that Megan's gonna touch on. It's something called a writ of mandamus. That is another option in these cases that kind of deserved its own category because it's in a category all its own.
That's accurate. It basically is suing the court or law enforcement. So we really would strongly suggest slides 2 or 3 if possible.
Try those first, but we will touch on it so you know that it's out there. Okay, Nikki, next slide, please. Okay, so to start off our intro, here's a video from Judge Judy, where I think the underlying message here, the underlying kind of frustration here may sound familiar to many of our advocates out there.
Woof.
So I think there, Judge Judy perfectly kind of shows the problem that so many of us face when we're talking to law enforcement or others who may confuse custody issues, and thus leads to a common dilemma. Those who have the power to help custodial parents retrieve their children are often hyper-focused on, is there a court order? Show me that you have custody. And they seem to misunderstand the laws in Minnesota that govern custody and parenting time of children. And yes, this slide perfectly captures our reaction. That's not great.
I do just want to point out that we're going to be throwing around a lot of sort of legal terms, and each one of these terms have a specific definition by statute. And so we are going to be talking about when the child is in your physical custody, like you have custody of a child. But we just also want to make sure that we don't want you to confuse that with statutory custody.
Yes, I appreciate that. Yeah, because we are going to be saying the word custody quite a bit, so that helps. Okay. All right, I'm ready for the next slide, Nikki. So how can this happen? How can this happen that so many of us statewide are having this issue where there seems to be a confusion between parents who has custody, who has the rights to the child or to the children? So during our work, both at Standpoint and at SMRLS, where Megan works, we receive, as stated, a high number of calls from mothers and their advocates and their attorneys working with them regarding situations where the biological father or sometimes another family member has removed the children from that custodial parent's care and is refusing to return them. In the context of the calls we get at Standpoint, at least, this not always, but commonly happens when the other parent, the one who removed the children, is abusive and refuses to return them. So maybe they refuse to return them after an informal visit, like the mother allowed contact, and then the non-custodial father just refused to return. It can happen when a parent is refusing to follow a court order, or even something more extreme, like where the non-custodial parent will pick up the child from school, daycare, or a family member's house without permission, leave with the child, place them in an unknown place like a relative's home, and then again, just refuse to give them back. And so in those cases, the natural reaction for many seems to be to call law enforcement to help them enforce their rights. Help me get back my children. However, in our experience and what we've heard from our callers and our clients is that law enforcement is often, not always, but pretty frequently unwilling to intervene because they deem that this is a civil issue and that the only resolution can happen in family court. So in our view, this approach from law enforcement sends a message to a non-custodial parent that they don't have to follow the rules. It also, in our opinion, puts the burden on the wrong party. They put the burden on the mother to show that she has custody. So how does this happen? What we have here is a flow chart that can help you determine who has custody. And in Minnesota, the matter of who has custody of a child boils down to either statute or court order. The flow chart displayed here is also included in our handouts in the Dropbox link that we sent. So the problem in part is also illustrated here, that the issue of custody of a child can seem incredibly complicated. So law enforcement may have internal policies that say they don't get involved with returning a child to their custodial parent, even though the child may be in harm, and a custodial parent seemingly has no other way to secure their return. If you have a court order, it can be simpler in a sense. It's written out who has legal custody, who has physical custody, and who has parenting time. Here, we're not focusing so much on parents who are married and don't have a court order. They're presumed to share custody and they would need to get an order like a divorce or an order for protection that would address this. But one of our main focuses is on unmarried mothers who cannot secure the return of their children. So this is when we say custody is either by court order or statute. This is when statute comes into place. An unmarried mother in Minnesota has custody pursuant to statute until a court order says otherwise. So just by virtue of being unmarried at the time of birth, mother has sole legal and sole physical custody until a court says otherwise. So this is true even if the parties have signed a recognition of parentage, if the non-custodial parent, the biological father, is paying child support, and true if that non-custodial parent is regularly seeing the child. The statute that addresses this is 257.541. It's also included in our handouts.
And what a lot of people I don't think realize is that when unmarried parents have a child together, they sign something called a recognition of parentage at the hospital if both parties are willing. Now, the recognition of parentage is very clear that it's not to confer custody, but then both parents show up on the birth certificate. When you have unmarried parents who both show up on a birth certificate and you have law enforcement that doesn't want to do it anyways, they'll find any way they can to be like, oh, that's a civil matter, this is the parent. So
Exactly. What I was going to say next, I agree that that does confuse things. A recognition of parentage makes father, legal father, but gives no rights. It specifically says that on the recognition of parentage document, just like you said, and it says it in the statute 257.75, which governs recognitions of parentage. Both of those are also included in your handouts, and we're gonna talk later about how just those are good documents to have on hand when you are working with law enforcement. And it can be confusing. I was just kind of researching the other day for this, and I saw even on a family law firm's website, they said on their website, unmarried mothers have sole custody unless the recognition of parentage is signed. And that's just not true. The recognition of parentage doesn't give any rights to custody or parenting time. So even the professionals can get it wrong. It can be confusing.
Ask Beth offline who that is and don't hire them. Just saying.
Yeah. So again, just harping on the problem, these unmarried mothers are often told to go to family court. You don't have your child in your care, go to family court to fix this. But they're in essence being told to go to court and spend potentially a lot of time and money to get something they already have pursuant to statute. Again, so in essence, the burden is being placed on the wrong party. It should be placed on the non-custodial parent to prove that they have custody. If they're unmarried and they're saying they have custody and parenting time, they should be able to show a court order. So again, one of our overall goals is to go over strategies to help alleviate this very common statewide issue that we're seeing. And in addition, we'll be discussing not only what to do if there is no order, but just a statute that determines custody, but also methods that you can use if there is a court order that governs custody. Okay, that was a lot on this slide. Again, we have this flow chart in our handouts. Really, custody boils down to if there's a court order, you follow the court order. If they're unmarried parents, mom has sole legal and sole physical custody until a court says otherwise. Okay, we got a comment asking if Megan can speak louder. Is that hopefully your new headphones will help with that, Megan? I don't know. Do you have anything else on this slide, Megan, before we move on? Okay. So as stated, we're going to start with what can you do as an advocate? What options can you give to your client if there already is a court order that governs a parenting time schedule, but one parent is not following that? Should be simple, right? Because there's the court order. Unfortunately, not always. Go ahead, Nikki. So the first thing that we would encourage you to do if a client comes to you and says that their children should be in their care and the other parent's not returning them is help your client determine if there is a court order, determine what it says, and determine if there's any order out there that supersedes it. So examples of a court order that may be relevant here are a divorce decree, an order for custody and parenting time, an order in a paternity matter, or even an active order for protection that outlines temporary custody and temporary parenting time. It's not uncommon, unfortunately, for people to forget if they have an order or to forget what it says. Maybe they're working off an old order. I've seen people where their cases have been dismissed and they didn't realize it, so they were working off an old order in a dismissed case. I've also seen people where they've been following an informal schedule for so long that they forget what the underlying order actually says. So you want to make sure that you and your client have a good baseline from which to work. Is there an order? What's the most recent? What does it say? From there, we encourage you to work with your clients to establish their goals. So the goals of the client may inform what options they choose to pursue. So some goals we mentioned here are safety, efficiency, correcting an order, or clarifying. So like the first two that we mentioned, efficiency and safety, seem the most likely for the bulk of these situations where a custodial parent is urgently seeking the return of their kids. They want the quickest option that's as safe as possible for them and the kids. But for other clients, you may see that what they really need is a long-term solution to clarify their order, to make it more enforceable, or to get rid of any discrepancies or loopholes that the other party may be taking advantage of that's making it hard to really follow the order or enforce it. This may become more clear once you read through the order and determine exactly what rights and responsibilities are outlined in that order.
I do have a practice tip here. There is a part of the statute that allows the court to insert a provision that says law enforcement shall help enforce this order.
Right.
One of the roadblocks that we come to is law enforcement says, well, I don't have any authority to take the child into my physical custody or to do anything.
Yep.
Well, there's actually a statute that says the court can order them to do this. I see it in very few orders. I put it in every single one of mine. I want it to be very clear. I don't want to have to waste time going back to court to be like, okay, yes, you have to enforce this, please. Thanks. So just I would, on the front end, always make sure that that's being requested when you go, if you have to go to court to do this.
Yeah. I think that's a really good idea, is when your client is in the process of building these orders, like they're in litigation or they're reaching settlements, it's always best in these orders to be as specific as possible. And also, I think, to have built-in enforcement and built-in consequences. If A does not happen, custodial parent can do X, Y, Z. It really helps to avoid having to go back to court. We also encourage you to check for alternative dispute resolution provisions in the order. For example, was a parenting time expediter assigned? Do they have a mediation clause? That's becoming pretty common in family court orders. Some judges are strict about them and enforce them. And like everything else in a court order, it's good for a party to know upfront what they're working with before they decide to proceed. And then last, even with the court order, you can seek enforcement from law enforcement and report a crime. That's going to go into detail in later slides about the best way to do that.
So one other thing about ADR is that the court can't require someone to engage in ADR if they are a victim. And so when clients are going into court, again, this is advocacy on the front end before we get to this point, but just a practice tip that remote technology has made things safer. That doesn't balance the emotional sort of playing field. And so significant amount of time and energy goes into assessing whether or not that's appropriate. And if they don't want to do it, they absolutely can't get ordered to over their objection.
Let's we had a couple questions, Megan, about your practice tip about law enforcement shall enforce. We do address that on the next slide. Let's go there. Yes. That might kind of help.
And the statute is 518.175 sub 1D. I knew someone was going to ask.
Yeah, our little yellow square there has it written out too.
Good.
Yes, but that's a great tip. And this slide is a little bit more on, again, if there is a court order, it's not being followed, what are some ways that your client can enforce or modify their existing order? Again, it depends on what the issue is and what your client's priorities are, but we can just kind of run through some of these options. Our first square in the top left is filing for contempt. So contempt is, in essence, saying to the court that the other party is fully aware of the order, they're not following the terms of the order, and they don't have a good reason for doing so. The purpose of contempt is to compel future performance, not to punish past bad acts. Like many things in family court, contempt is not quick. It can be a multi-step process, but it is one way to attempt to hold someone accountable and put an order into place that will compel the other party to comply with an existing order or face consequences if they fail to do so. I think you most often see contempt for non-payment of child support or spousal maintenance, but it can also be used for not following a parenting time order, and I have seen it used that way. There are court forms available on the Minnesota Court's website for filing for contempt. They have it labeled for filing within a divorce decree, but I've seen it also used in custody cases. Our yellow square is another option, filing for parenting time assistance. This can be done in any case that ordered custody and parenting time, so paternity, a custody case, or a divorce. So parenting time assistance is an umbrella term for filing in an existing order to change something about the existing parenting time schedule. So changing the schedule, making visitation supervised, changing transportation, making the exchanges supervised. Those are all options. You can make a schedule clearer and more enforceable or safer, or ask to build in consequences for not following it. Megan, you looked like you had something to say. Go ahead.
Always.
Yeah.
Filing for parenting time assistance is like the kid glove version of contempt. It doesn't have the same teeth that contempt has, but
Yeah.
judges, in my experience, are far more receptive to just a plea for help rather than a get 'em for
Yeah.
whatever reason, even though it's totally allowed and appropriate in certain circumstances. If you're not quite to the point where like you really need a judge to get in there and make this other party do what they need to do,
Yeah.
you might be better off starting with a request for parenting time assistance to make sort of some changes so that the parenting time agreement is easier and more enforceable. But yeah, contempt is it's a big stick.
I totally agree. And I've seen that too. I think it's, and for some judges, they see contempt as this extraordinary remedy. So you have to try the more ordinary things first. And that can include parenting time assistance. Through parenting time assistance, you can ask for compensatory parenting time. So let's say maybe some time was withheld, but your child's back in your care, but you want to kind of have a punishment for that past time. The court can grant makeup time for that time that was missed. As noted in a parenting time assistance motion, you can ask exactly what Megan cited before, that the court may provide that a law enforcement officer or other appropriate person will accompany a party seeking to enforce or comply with parenting time. You can also, if you don't have a set schedule, which is never advised, but if you do have one of those orders that just says reasonable parenting time, or they're going to split and the parties agree that they'll agree on a schedule, doesn't always work. You can go in and ask for that specific schedule.
Historically, courts used to love percentages, and that was like all about the child support. Were they up to 10% or 10 and 45%? And so they're less inclined to do that, but older orders still have those percentages in it. And people really want these cases to be over. And sometimes they're like, yeah, we'll figure it out. Yeah, we got this.
Exactly.
Like,
and judges are like, great, get out of here.
Good luck to you.
Go figure it out. Exactly. Okay, before I keep going, I'm just checking our Q&A. Kristen says,
got it.
Analogy, Megan. Megan's awesome. So yes, I agree. Whatever analogy she made was amazing. Rachel, I will be touching on emergencies just in a little bit. So thank you for asking that. Okay. Let's see here. Where did I leave off? So you can, I think our little gray box there just says request to restrict parenting time. I would fit that within a motion for parenting time assistance, can change the schedule, can make it supervised. You can also file to modify custody. So not only seeking to change that parenting time schedule or change something about it, but you're actually seeking to change the labels, physical custody and legal custody. In my experience, harder to do than a parenting time assistance motion. There's more requirements that go into it. And again, modifying custody can be a long and difficult process, but long-term it can be a solution. And statute that we have cited there, 6H, does say proof of an unwarranted denial of or an interference with duly established parenting time may constitute both contempt of court and may be sufficient cause for a reversal of custody. So long-term withholding of parenting time or interfering with someone's parenting time can be a basis to modify custody. The 518D that we have cited there, the bottom middle, that, Megan, that's more like if you are, I see that as more if you have like an out-of-state order and you're filing to enforce it here. You can also ask for the an officer to take physical custody of the child if the child is likely to suffer physical harm or be removed from the state. Is that your experience with that too, Megan? I've never used that one. I just know it's out there, but never had to do anything.
Again, the warrant to take physical custody, that's just necessary if law enforcement says that, well, I can go with you to enforce this order. I can accompany you, but I'm not going to physically do anything or take this child. So this is what tells the officer, yes, you will do this. And it is not only used in interstate. I don't use it as often because I'm typically trying to do more than just get a kid back.
Yeah.
But if that was, one of the goals, you know, speed, efficiency, things like that, you could certainly request.
Okay, thank you for that. And then lastly, mention for all the things I've touched on so far, parenting time assistance, modification of custody, you're going to see that in family court. Those are going to be in your custody cases, your paternity, your divorce, whatever ordered custody and parenting time. You may have a situation where a client doesn't have a family court case, but they have an order for protection. And as you know, some orders for protection can issue temporary custody and temporary parenting time provisions. If that's what you're working with, that's going to have a separate set of remedies. You're not going to file for parenting time assistance or to modify custody within an OFP. You can file to modify an order for protection. You can file for contempt within an order for protection. That's also possible. I don't think super commonly done, but it's out there. You can also just call law enforcement and file a violation of the file a violation of the order for protection.
On certain occasions when there's a significant safety concern, in my experience, when I help a client report a violation of an order for protection, law enforcement doesn't always take that individual into custody as they're required to,
right,
under statute.
Yeah.
And so in the last couple of years, the excuses I've got are COVID related. We don't have enough space. We can't do this. But if that's something that you need done, this is a requirement. And then we can talk about that big mamma jamma, a writ, and about suing law enforcement at the end of this. So just keep that in mind.
And then we got a question on if you can file any of these family court cases as an emergency. So
yeah, I think if the circumstances, if
it
meets the requirements, yeah.
Most things in family court certainly don't move quickly. You know, for your typical motion, you're going to call court administration and ask for a motion date, and they give you what's on the court's calendar. Kind of depends on that district and that judge how soon they can get you in, and then your motion has to be filed and served 21 days before. The Minnesota Rules of General Practice do allow for emergency motions in family court. You have to have an existing court case. You can't just open a case with just an emergency motion. And basically you have to allege enough facts to show that the court that they should bypass those normal filing deadlines. And we don't have a checklist in Minnesota of what's an emergency and what's not. Basically what you're looking for is that you can show enough that if the court does not act immediately, irreparable harm can occur to the children. If you can show that, yeah, you can get an emergency order in family court. The court, if they issue an emergency order, they have to have a hearing within 14 days.
Yes, Leona asked if this could be filed pro se. Yeah. None. I hate to say it, but like, I'm not required to do any of this. I highly suggest a knowledgeable lawyer be consulted when doing one of these, but I'm not required.
Yep, and like forms for modification of custody, parenting time assistance, contempt, those forms are all available on the Minnesota court's website. So I think they do what they can to make it as user-friendly for those who are self-represented. Forms for emergency motions are not statewide. Some counties have them available, some counties do not. It's not consistent. If you are in a county that does not have sample emergency forms, that's a situation where you can call Standpoint and I can do my best to give you a template that would work for your situation. I will just say, I think, Megan, that in a lot of cases, if let's say a parent's not following the court order and they're keeping the child, but the child's not in any danger with the parent who's keeping them, a court may not grant that as an emergency motion. They may say you kind of have to go by the normal filing deadlines.
I think it depends on how you define in danger.
Yeah.
I think there are a lot of resources out there that talk about how important stability is for children. And so, I mean, irreparable harm, maybe. So I think you can define it broadly, but I think you have to be very careful to back it up with why you think that without the court's immediate intervention that this will happen. Well, you know, dad doesn't like my family, and so they're gonna, he's gonna alienate them if he gets an opportunity, or they don't give him the medication that they're required because they don't believe in mental health. So the first one's probably not so much. The second one,
So case specific and do your best anytime for your filing for emergency motion to back up the facts. Okay. All right, I think we're ready to move on from this slide. Okay, so then that was all what you can do if there is a court order. If rights have already been defined, but they need some clarification, they need some enforcement. Now we're moving on to a section of what can your client do if there is no order establishing a parenting time schedule, which sometimes in our experience can be the toughest situation to deal with. Okay, go ahead, Nikki.
So hi.
Go ahead.
Is this your slide?
I think it's my last one.
Good job.
And then move on to Megan. Yes, but feel free to jump in. It's pretty similar that we start by encouraging you to work with your client to establish their goals. Efficiency, safety, corrective, or clarifying are all example goals again. Again, in these situations where there's no court order and your client you're working with is by statute the custodial parent and they can't get their child back, it's very likely that their goal is to have the safe return of their child as soon as possible. One option is to contact law enforcement and report a crime. I'm not going to go into that super in detail on this slide because Megan is going to pick that up in the next few slides about the best way to do this. Clients in this position may want to avoid court involvement as much as possible because as noted, an unmarried mother already has sole custody pursuant to Minnesota statute and shouldn't have to go through the time and expense of involving the court. Unfortunately, sometimes that's the only option, which is why we include that one option is for the parent who's seeking the return of their child to file a petition to establish parenting time. If appropriate, they can ask for a protective order and ask for relief that's not only for safety, which is the primary focus of an order for protection, but also ask the court within that order for protection to recognize their custody status or grant them temporary custody and order the immediate return of their kids. So it's different than asking for it on behalf of the kids. It's very specific relief within an order for protection to return their kids and recognize their custody status. And of course, the option for a declaratory judgment, which we will be going into later. Okay. And Megan, I think you're going into detail in most of these later, so I didn't have much to add on this unless you did.
No, I think the having petition to establish parenting time here, we included it because it's an option. It's probably one of the options of last resort, because
Absolutely.
When you do that, you open up the individual to have the other parent request parenting time and custody. And so we want to make sure that we are doing this in a way that protects the rights and of each of the parties and the parents. Yeah.
It's absolutely something they shouldn't have to do. It's an option out there, but it opens the door for sure.
All right, next slide. So what can you do if there is no court order? Well, you can play nice. You certainly can. Most of you on this training are here because you know how to play nice, and playing nice only works, well, in my own unverified study, playing nice only works 7% of the time. Now, it's a very, very emotional time for clients when they don't know where their kids are, they're not safe, and they're frantically trying to find them. As much as possible, though, it is helpful at that point to also start to think a little bit strategically. Yeah. You want to set them up for the best possible way to get their kids back. And one way to do that is to document your efforts. If you do have unmarried parties that have an informal agreement, that's great. You don't have to have a court order as long as you have an agreement. Put it in writing. Make sure that if the non-custodial parent gets every other weekend, well, even though I've gone to law enforcement with just a text message, I've gotten kids back. And it was helpful that my client at the time said every other weekend starting the weekend of July, whatever. Because I've also gone to law enforcement with that same text and no date. And they said, well, we can't figure out whose weekend it is. So we waited a week for the second weekend to go around. I was like, okay, it was either that weekend or this weekend. Let's go get those kids. So, and they ended up helping, but it was an unnecessary amount of phone calls. We talked a little bit about working with law enforcement. So if you try to work with the other party and you can't do it, law enforcement is an option. It is a crime, specifically deprivation of parental rights. You can report a crime. Often you will hear that's a civil matter.
Yep.
Now, I live in the civil court system. That is where divorce cases, custody cases, child support, protection orders, evictions, that's where all the magic happens. And then there's this other part that is what everybody thinks court is that law and order, like, you know, criminal justice system, ding, ding. And so law enforcement sees their role as enforcing, you know, preventing crime and enforcing rights. Now they say they don't do civil work, but do you know that sheriffs actually have to serve eviction notices, which are civil? They hate family law. That's what it is. I get it. I get it. So don't let an officer telling you that this is a civil matter deter you, because while it is a civil statute that gives an unmarried mother the custody of a child who's born outside of marriage, it is also a crime to interfere with that right. So you're not asking them to enforce a civil statute. You're asking them, or you're reporting a crime.
Yep.
Now, we do have a couple sample letters to give you an idea of some of the ways that you can work with law enforcement on trying to resolve this without conflict, as much confrontation or as little confrontation as possible. Just like I tell people that I supervise newer attorneys, I say, clients are going to come and go, but opposing counsels will be forever. So sometimes, even though you don't enjoy working with them, you have to realize that you are going to be interacting with this law enforcement agency or this sheriff for a foreseeable future. And so building that relationship on the right foot is incredibly important. And they don't love being told what to do. Especially from some Mankato City folk. I practice in southern Minnesota, so they think we're big city up here. So deprivation of parental rights, I will talk a little bit more about that. But yeah, we have included sample letters that you can use to establish that you have in fact made a report to law enforcement. Sometimes they will try not to make a report, try to say this isn't a criminal matter. Not only are we not gonna do anything, but we're also not gonna take down your report. So providing them with a written claim of a crime and that you're asking them to open a report. Again, that's for the big stick later on, but you want to make sure you put things in writing that, okay, I just want to clarify, you are declining to provide, you're declining to open up an investigation. And one of the reasons that that's important is there are ways to recover costs and fees through the Crime Victim Reparation Board later on down the road, but an incident report has to be made.
Okay.
All right, so what is a deprivation of a parental right? The statute that is in the criminal code is at 609.26. Sub 1.3 is, it doesn't just have to be that subdivision. So I wanted to point out a couple other instances where failure to return a child might result in a charge of a deprivation of parental rights. So intentionally concealing a child to substantially deprive a parent of their custody rights. That, if you're going to try to use that one to report, it's harder because you have to show that they are doing this intentionally. And typically law enforcement wants to see a significant period of time for it to be a substantial interference. It is so easier ways to report a crime would be is if somebody refuses to return a minor child to a lawful custodian and is at least 18 years old and more than 24 months older than the child. I'm not great at math, but I guarantee you 100% of these non-custodial parents are going to be more than 24 months older than the child. You'll have to make sure they're over the age of 18, but I'm pretty sure the second part is going to be no problem. Contributing to a child being a runaway. A runaway is a child who's absent from a home of a lawful parent without the consent of the lawful custodian. Where this statute gets law enforcement confused is the use of the word parent. Most of the time, these individuals are not contesting paternity, meaning a legally established, based on biology, relationship between the child and the non-custodial parent. And that if their rope is signed, then they're going to be on the birth certificate. There may be a history of parenting time that they're exercising. And so unless it's, unless you explain to law enforcement exactly what you're needing to report, they may dismiss it. So make sure that you are looking at which of these you want to report under.
Mm-hmm.
Missing person report. Law enforcement is required to accept a report of a missing person. And it made my heart so happy reading the statute. It was like, it doesn't matter the relationship. It doesn't matter like how long they've been missing. Like if somebody says someone's missing, like you open a report. The exception to that is if law enforcement has direct knowledge that the person is not missing and their whereabouts and welfare are known. So if you say, I'm filing a missing persons report and you know where the child is, and law enforcement also knows where the child is, missing person, a report of a missing person is not going to be the best avenue to help you get your child back. If a missing person report is made, the preliminary investigation must take place. Law enforcement has, and I will go into this a little bit later on, but they have certain requirements and responsibilities and standards of conduct. And some of the most fun things that I get to do is I get to read these police policies. There's one on missing persons, and there's one on domestic abuse calls. And it lays out very, very clearly what the expectations are for the officers, how they are to proceed, how they are to document it, how they are to treat, and be respectful of these kinds of cases, because dealing with victims is, we want to minimize, not re-traumatize individuals. So when I can go and they say, well, that's not our job, I'll be like, yeah, it's kind of your job. Sorry. Now, law enforcement agencies on certain circumstances are allowed to adopt their own policies. I've found zero overzealous law enforcement agencies that want to like sit around and draft something new when they are handed a model policy. So it's very uncommon. The last option is to file a restraining order. There's a order for protection, which would require allegations of domestic abuse.
Yeah.
Now, if the client is a individual who's a victim of domestic abuse, the court shall award custody and parenting time that is in that survivor's best interest and is with their safety as the paramount consideration. So even though a child may not be a protected person, the court could still award custody and parenting time while keeping that victim's safety paramount. The other option would, if you're worried about the other parent asking for parenting time and in order for protection, and you should always understand that that is an option for the court to order custody and parenting time under the order for protection. There is a harassment restraining order, and that would just prohibit the non-custodial parent from contacting mom, and probably you'd have to do the child on that as well. So there would have to be some sort of, you know, again, with the medication example, where the non-custodial parent is refusing to return the child, and they tell the child that doctors are evil, and they make them watch these terrible YouTube videos about all the things that are going to happen to them. So that might be an instance where a harassment restraining order may be appropriate. All right, next slide. I wrote both of these, so don't judge Nikki and Beth. I'm a bit of a softie, even though I'm a little sassy. I am 100% with you when I say that this is a passion project of mine. I love rules, and I really like to encourage people to follow them. And so I've been practicing now a little over 10 years, and this issue has been around before my time, and danged if it's going to be around after my time. So when I had a client who couldn't get their children back, I was thinking we had this mechanism in city utility cases where utility companies were not restarting services, even though they were required to. And so we would bring declaratory judgment actions to confirm they have an affirmative obligation to restore these utilities. And I thought, that sounds kind of fun. I wonder if we can use it in family law. So in 2015, I was contacted by a client who was the mom of 2 teenage children. Repeated requests from law enforcement to help return the kiddos. The children were older, so there's always that issue. Oh, well, the kids don't want to come back. Yeah, that's why they're kids and don't have fully formed brains until they're 26. So while I appreciate that they might want to stay with the non-custodial parent, who at the time was an active drug user and had 0 rules and did not make the children go to school, I can understand why those children may want to live in sort of a free reign free reign household. So I contacted law enforcement where the non-custodial parent lived to help. No. I contacted law enforcement where a client lived. No. So I said, well, let's file an action for declaratory judgment. This is my very first one ever doing it. And I hate to tell you, it's the only one I've ever not gotten, but I'll tell you why. So we filed this action for declaratory judgment, and this judge was retired. He's seen it all, not seen this. So we get in court and he's like, Ms. Mays, what are you doing? And I was like, I'm bringing an action for declaratory judgment so we can say that mom has custody. Well, this should really be done in family court. I'm like, maybe it should be, but we're here in declaratory judgment land, so let's move forward. The statute allows you to bring the case in the venue where the right is being violated or where the violation occurred. And so that judge said, well, the violation is occurring in this other city, so we don't have jurisdiction, and he dismissed the case. And I'm like, let's appeal it. And we totally would have won. But what was best for the client at that time in that very limited circumstance was to petition for custody and parenting time. And so we ended up petitioning for custody and parenting time. We requested the same emergency relief as in the declaratory judgment action. We ended up getting the kiddos back. So while I was unsuccessful in the declaratory judgment action, it did not deter me. And I've probably done about 20 declaratory judgment actions. Most of the time, there's other things that I can do that will minimize the adversarial nature of getting the kids back, or trying to do it in a way that's, you know, less confrontational or things of that nature. I've also represented a unmarried father who was raising his 9-year-old child for 2 years. Mom was up from Texas. Dad let mom have, you know, see the daughter because she hadn't seen her in a couple of years, and mom fled to Texas with the child. Didn't tell the school, didn't tell dad. Within a few days, we got a ex parte order ordering the child to be returned from Texas at the sole cost of the parent who removed the child. And they had we requested a very short window. They wanted to say, well, I can't do it this quickly. It's like, well, if you can choose to take a child out of the home of their, you know, in this case, it's not a statutory custodial parent, but the parent who had been providing the care for the last 2 years. And so it was really good to be able to educate the court a little bit and to help an unmarried dad who is doing the right thing. So it's not always moms, you know, sometimes it's aunties or third parties or things like that. So, all right. I also titled this next one, Full Responsibility. Yeah, be the change. So I've been harping on this since 2015, and Mama tired. So I'm so happy that this is a turned out training, and that we can offer a lot of resources and options to really make change. I don't want to have to keep doing this, you know, sneak around sort of basically just to enforce. It's not a sneak around. It's a lot of work, and it's very blatant, but yeah, I don't want to have to do this forever. There are some very, very friendly jurisdictions that perhaps the chief judge or a different judicial officer or some other individual that law enforcement might listen to could issue a standing order that says all unmarried moms have this. One agency office that will have a lot of impact as to how law enforcement treats failure to return a child reports is the county attorney. Yep. The county attorney, law enforcement investigates, county attorney decides if to charge. And if they're never going to charge a deprivation of parental rights case, law enforcement is not going to waste their time.
And if you look at our handouts, we have one of our sample handouts is just one of these county attorney letters. So a letter from the Rice County attorney, and just indicating exactly what the statute says about unmarried mothers to make that clear. And my understanding in Rice County is that that's helped clear up a lot of these issues, having kind of, it's not a standing order, it's a letter from the county attorney, but it can help clear up for law enforcement exactly what's what and what they should be enforcing. So just, we would encourage you, if you don't live in a county that has a letter like that, and I think that's most of you, because most don't have a letter like that, is to try and be that system change and request a letter like that or a standing order from your judge, if possible, in your county.
A great place to do that is task forces. If you have a task force in your community that is there to help survivors, even though not all of these individuals are victims of domestic abuse, sexual assault, or stalking, or that some of them are. And any way that you can get that judge's ear and get them to be on board with this, the more likely the prosecutor's office is and the law enforcement office will be to sort of fall in place. We had talked about the letter before, which is the one we had talked about, documenting the report to law enforcement and the requests that you're making, and making sure that that's in place if you need to take a next step. We have printed statutes regarding the unmarried parents' right to custody, deprivation of parental rights. And what was the other one? Was that the rope?
The recognition of parentage statute that specifically says a recognition of parentage does not give rights to custody or parenting time. Because sometimes you will see that's a very confusing factor. A party will be waving that around saying they have rights. Law enforcement can be legitimately confused by it, and that can help. Just having that statute ready to go, printed to show to law enforcement, I think can be really helpful when you are contacting law enforcement for these issues.
I talked a little bit earlier about the Crime Victim Reparation Board. I always ask the parent who is withholding a child to cover every cost associated with returning the child. That isn't always possible, and so making a report to law enforcement officer and keeping all receipts of like lodging or meals or gas, for example. You can make a request to the Crime Victim Reparation Board to reimburse you for those costs. Okay, next. All right, so working with law enforcement, super fun, best practices. So I don't want anyone here to think that I'm dogging on law enforcement. Like I understand that they have a very difficult job, and I respect a lot of law enforcement officers and what they do. Some of my interactions with law enforcement lead me to believe that there may be room for growth in various areas in agency departments. But what their real goal is to detect crime and enforce criminal law, promoting justice and public safety, by preventing commission of crimes. And they talk about crime is conduct prohibited by civil statute, in which the actor may be sentenced to or imprisoned with or without a fine. Because deprivation of parental rights is a crime under criminal law, the victim of that crime also has additional rights under Minnesota statute 611A regarding the process and how what their role is and how they can expect things to be handled. So that is another place to go for rules. Go to the next one. All right, so like lawyers, they have professional standards of conduct. There are licensures, there are training requirements, and there are also practice standards for them. And the reason why they do that is they want to have the public have confidence in the integrity and the ability of law enforcement to do their job and to do it well. If a police officer intentionally fails or refuses to perform a known mandatory duty of their office, they are committing a crime themselves. And there are requirements, just like for lawyers, that if you know or should know of another individual who is violating their professional standards of conduct, that you have an obligation to report them to the post board. We'll go on to the next one here. So it's really not only important to understand how courts work, but it is important to understand how the criminal justice system interacts and can help secure the return of children to the parent that they're supposed to be with. Again, this is one of those policies and procedures. If there's unprofessional conduct, you can request the policy so that you know how to make a report. It can result in disciplinary action. And if the chief law enforcement officer is refusing to process the complaint as required, then they are in violation of a separate duty as the chief law enforcement officer of that agency. Upon request, copies must be made available to the public. If you are practicing in a couple different counties or a general area, it is really, really good to get to know the procedures in your community so you can work within them and sort of talk their language.
So Megan, would you request too that advocates reach out to the law enforcement agency that they're working, that's in their county, and ask for copies of their policies?
Anyone of the public, anyone can request a copy of these policies. Absolutely. I think it would be good if advocacy agencies had this information, because there are bad eggs in every profession, and there are times when this might be, appropriate.
And do you, so we talked about sending out, like, if you're trying to report a deprivation of parental rights and working with law enforcement, we talked about sending a letter.
Yes.
You also recommend before someone takes next steps that they follow that complaint procedure, which to my understanding usually is work your way up the chain of command, right? Like make a complaint that they're not enforcing, that they're not taking a report, whatever it may be.
Correct.
Okay.
Yes, there's a difference between I want to speak with your supervisor and I want to file a formal complaint of unprofessional conduct. I would definitely suggest I want to speak to your supervisor route first. But if I am the supervisor, okay, different fact pattern. So.
We had a question, what is the best way to request these procedure?
In writing to the chief law enforcement officer.
Okay. And okay, Suzanne just said was just looking this up regarding law enforcement complaint process, and then gave the administrative rule that applies.
Correct.
Thank you so much. That's really helpful. I appreciate that.
Thank you. How often do these reports result in actual consequences? Well, unfortunately, we don't always get to know what happens after the complaint is made. If the chief law enforcement officer refuses to process the report of misconduct, then they are impeding the required process and they are opening themselves up to be liable for disciplinary action. As far as what happens after the complaint is made, that would be laid out in the procedure, whether or not you're even entitled to know what happens to them after the complaint is made. And it's very, very possible that unless there's a public or, a firing or a, discharge of the official duty, that you might not get to know that is happening. But if you are filing the same complaint on the same law enforcement individual multiple times, right, then it's time to go to the next step.
And sometimes what we're going to be talking about next is, all right, finally getting to the declaratory judgments. And I think sometimes even if you're not getting, your letters don't work to the police or your reports don't work, sometimes it's just a matter of documenting it so you can show a judge that you've tried something else, and now a judge, you need to act because law enforcement won't take a report. Look, I tried. So sometimes it's just the act of doing it to show that there's no other option. Okay. Are you ready to move on to declaratory judgment? Okay, I can go over the disclaimers.
Yes, please.
Okay. So part of what is in your handout in the Dropbox and what we're going to be going over some of the documents next is a packet for filing for a declaratory judgment. And again, a declaratory judgment is different from a family court case that we may be familiar with. A family court case is asking a family judge to establish custody and parenting time. This is a case in civil court asking the court to issue an order declaring what is true, that an unmarried mother had sole legal and sole physical custody pursuant to statute. So this packet that we provided is for very specific case circumstances. The ones that we have drafted up here and provided to you are when you're requesting an ex parte order, so an emergency order without giving prior notice to the other side only. And so, because that's going to be obviously, if it's an emergency, it's your most urgent situation. I totally recognize that it's not only in emergency situations that unmarried mothers may want an order outlining their custody status. I've seen cases where schools ask for it, or daycares, or that mother just kind of wants to get their ducks in a row. That all makes sense, but these particular forms, because we've provided them in a group here, are for those emergency situations. As with any type of ex parte emergency relief, it's not available in every situation, and it can be a high burden to meet. So the facts and circumstances of each case are going to determine if this packet of forms are appropriate. But generally, kind of like we said before in family court, an emergency situation requires a potential for immediate harm to the child should the court fail to act. We do, as stated before, recommend that before a party uses this form, that they document their efforts through law enforcement or other means. So that can include kind of what is appropriate and safe in their situation, documenting that they've reached out to the other party, to their family members, to daycare or school, whatever it may be that's appropriate in their situation, that you document all those efforts first, because that can go into this. These are not intended for use in situations where parties have an existing family court order or a pending family court order, like in a divorce or a custody file. If you have that, utilize one of the options that we went over before: parenting time assistance, contempt, whatever it may be. I think most important to know is these are not statewide approved forms that you're going to find on the court's website. These are forms that Megan came up with to solve a problem, and then we fine-tuned and we wrote up an instructions form. So we're asking you to basically take a chance. You may be in a county where a judge has never seen this before, and maybe like Megan's first judge. What are you doing? But these are all actions that are have a basis in court rules and statute, and these are all appropriate actions in our viewpoint. But just to know, they're not these state approved forms that you're going to find on the court's website. You're only going to find them here that we provided to you.
You heard it here first, ladies and gentlemen.
It did sound like an infomercial when I said that.
But that's okay. For the low price of free, we'll give you the packet.
Okay, I think that's all my disclaimers. And we're going to be going over the forms. You don't have to frantically write down instructions. We have an instructions form that we provided you to, and you can always call for follow-up questions and advice. And we do encourage you to seek legal advice before you use these. We can help you determine if it's appropriate in your situation. Okay, I think that's all the disclaimers that I had. It was a lot, but okay.
So we've said the word declaratory judgment quite a bit. I don't know that we have explained exactly what it is. So the declaratory judgment is a court action in which the court will determine rights and responsibilities and legal relationship between parties. So for example, we are going into court to declare that an unmarried mother has sole custody until a court's order states otherwise. They have full force and effect of a final judgment, so a final divorce or custody order, a paternity order that sets out custody or parenting time. This does that exact same thing. When used properly, it can prevent costly litigation. Very, very rarely, in my experience, does a declaratory judgment action get followed up by a petition for custody and parenting time? But it does happen. And if they do petition for custody and parenting time during the declaratory judgment action, that action would then become moot because there is a court, there is a court file open. So while the court may have a very limited ability to say for the time being, mom has sole custody, but that right can change by a later court order. Next. Okay. Me?
Still you.
All right, so drafting, we did the packet. That will help you with that step. Once all the paperwork is together, then you're going to have to file it with the court. The adverse party will get served with the paperwork. That may be after the court issues an ex parte order. Again, if there is that irreparable harm, that if the non-custodial parent knows that a case has been started or that a order returning the child has been issued, that if they have that ahead of time, they could either flee or do something to themselves or others. You'll get a hearing after that. When the judge is on, I've had very, very short hearings where this is a very narrow issue, very narrow. Is there or is there not another document, order, or otherwise that says mom doesn't have this? And if not, then the court should declare that mom is.
It's not
and
like a family court case where it's what's in the best interest. And I'm concerned about this. No, that's not the issue here.
Yeah.
Are you unmarried parents or not?
Right.
Yeah.
And it's not on the mom to show that burden that she is the custodial parent. If you have an individual saying that they have a right to withhold this child, well, prove it.
Yep.
The court will issue a final order, and then you'll have whether you'll have all those enforcement remedies if that becomes necessary.
We have a question. Does the court serve a declaratory judgment on the non-custodial parent through mail? I think
no.
Is it more in your
The
experience?
court
Megan,
doesn't serve it, at least in my jurisdiction.
Once you get your ex parte order, like your one-sided order, because you're saying this is an emergency, I can't give notice.
Yep.
My understanding is usually they'd issue that order if they agree with you and then give you instructions to have that personally served.
Correct.
Okay. Okay. Okay, so this is just a list of all the documents that are in the packet. You have access to the packet through your Dropbox. Some of these we're not going to be going over today. We're not going to be going over the instructions and the civil summons and the civil cover sheet, because remember, this is a civil action, not a family court action. Those are pretty standard documents. We have them in our packet, but we're not going to be going over them. We can just kind of quickly run through these 4 documents that you see the underline. Those are maybe the ones that will need the most fine tuning. So how about, Nikki, can we start with the complaint for declaratory judgment? Okay. Okay, so this is one of the main documents that you'll see in your packet that you could help an unmarried mother in this situation we've been discussing fill out and file a complaint for a declaratory judgment. So a complaint is basically a statement of facts that explains why the plaintiff, and you'll see that in civil court, you use plaintiff and defendant instead of petitioner and respondent, which you may be more used to for cases like OFPs in family court. It's a statement of facts that explain why the plaintiff should have the result that they're requesting. So the blank part, Nikki, if you could just kind of scroll through, we're putting in the blank parts of where you're gonna have to fill in. So where each party is residing, the names and dates of birth of the kids. If you could keep going. Paragraph 11 is a big one that you can really help your client fine tune. particular facts to this case about what happened, how the defendant took the kids, and why plaintiff cannot secure the return of the kids from the defendant. We have later down a statement of fact that plaintiff has contacted local law enforcement and has been unsuccessful. A place where you can fill in if there's concerns about safety, explain that here. And then at the end, it's plaintiff's request for a declaratory judgment. So language that your client can keep, just exactly what they're seeking from the court and why. So this is one of your big documents that your client would be filling out and filing, but we've tried to make it as user-friendly as possible by really making it clear where they would have to fill in facts that are particular to their circumstance. Anything else on the complaint, Megan? I know we're kind of running low on time.
No.
Good, okay.
No, I think the instructions are going to supplement our quick overview.
Yeah, exactly. Okay. And how about next, Nikki, can we do the notice of motion and motion? So because we're preparing these forms specifically for emergency situations where an unmarried mother is seeking the return of their children, we've also included, there's a motion for an ex parte. So again, ex parte means no notice to the other side, temporary restraining order. And so this motion is where you state what you want the court to order. And if there are concerns about immediate and irreparable injury, loss, or damage, the court can issue an order without notice to the other party. We've included in here some sample relief to request, but that again can be tailored to the specific situation. For example, if the kids have been removed from the state, you can request that the defendant be held responsible for all costs associated with returning them to Minnesota. You know, what's going to fit your client's situation.
And I love number 4. Order law enforcement to enforce this, including immediately obtaining physical custody of the child by any means necessary.
Yep.
You want me to kick down a door? Not particularly, but do what you got to do. And then saying that not only in this instance, but in the future, if this arises again, keep doing the things that you need to do to immediately, by whatever means necessary, return this child.
Yep. And then every motion, just like in family court, has to have an affidavit that supports it. So how about we look at that next if possible? So an affidavit, so your motion is where you're laying out for the court what relief you're requesting. Affidavit is your client's sworn statement that backs that up. It provides facts and evidence to support the request in the motion. And I don't mean you have to back it up by having like exhibits or a lot of proof. Your affidavit is a sworn statement and that is what you need. An affidavit should include all relevant facts that the party wants the court to know. So, and include an explanation of why emergency relief requested and a specific outline of the relief that you're requesting from the court. And again, if you're seeking ex parte relief, which again is relief without notice to the other side, which can be appropriate in an emergency situation or where you feel that the other party is going to take more steps to conceal the child or remove them, you should explain why notice should not be provided to the other party. And this is all in there with our suggested language. You should disclose if there's been prior attempts to obtain the same or similar relief. So if you've filed for emergency relief before or filed like an action like this before and what the outcome was. And that is, again, all in these sample forms. Okay. Anything else to add there, Megan?
Nope, that was solid.
Okay. Last document that we're going to go over, and again, that you have access to, is a proposed order. So this is, you're giving the judge a very clear understanding of what you're asking for. And if they agree with you that, yeah, this relief is appropriate, they can sign this order and file it. The relief should match what's requested in the motion and affidavit. And the courts can change this. It's just a proposed order, and ultimately the judges issue their own ruling on what's appropriate in the circumstances, but it's proposed to match the relief that the party is seeking.
Now, you'll see in there that it says in number 2 regarding the security requirement.
Yeah.
When all of my clients that I currently represent are all low income individuals. And so we will have an informa pauperis, which waives our fees to proceed in court. If you have an individual who does not have is not eligible to proceed in form of pauperis, the court can require a security bond. And I believe the general rules of practice set that at 2,000, but I'm not sure.
Yeah, but how we have it stated here is assuming that the party is going to be, if they're doing this on their own, very likely they may be low income. We're assuming they're going to file for fee waiver status. And so we put in sample language to ask for to waive that security requirement. Okay. All right, so those are kind of our 4 big main forms that we came up with: the complaint, the motion, the affidavit, and the proposed order. In the packet, there's also fee waiver paperwork, which is just standard. And then if your client does have an attorney, or this could be good for legal aid attorneys, if you're going to start taking on these cases, there is a sample affidavit of attorney that can accompany this paperwork. Okay. I think.
I know I set this up for like a grand finale because y'all are real excited about like suing judges and like law enforcement officers. But again, disclaimer, not recommended, but if you have to go there, go there. So if you need to do that, it's called a writ of mandamus, and the statute is here. Miss Nikki, thank you. So it commands the performance of a required duty. It can require a inferior tribunal judge and require them to make a decision to proceed, so long as it's not judicial discretion. You can't sue a judge because you don't like what they're doing if there's no order saying they have to do something different. That's not allowed. I looked. If there's a plain, speedy, and adequate remedy, again, this is not the kind of thing that you want to do. I had to write a strongly worded letter to a judicial officer once because we had filed for an order for protection and the court had not issued a ex parte order granting or denying it. 21 days went by and I said, hi, I would really, really, really appreciate if you would make your determination within 7 days as required by the statute, one way or the other, because we already requested a hearing, so we'll get a hearing either way. But you can't just not decide and leave my client unsafe. So I put at the bottom of the letter, please, 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 please do this. Otherwise, my only option is to writ you. I don't appear in front of that judge anymore, but it was super effective. They issued the order the same day. And then they put it in Mincis, like they issued the order first. And then I wrote this letter, but that's not what happened. But for another day. Again, it's an option, and I don't shy away from it, but I'm not advocating for it. I think there's always ways to find common ground or avenues that don't require suing a law enforcement officer or a judge.
Yeah, maybe not common, but just so you all know that it's out there.
It might be appropriate for you.
It might be, yeah.
All right. I don't see any questions in the chat.
No, we've been kind of answering them as we go along. So if we're ending right on time, which is amazing for me. I always go over. If there were any other questions, we're happy to answer them. Otherwise,
our contact information.
Yep, that's on the next slide.
Yep, I'll put that up on the next slide, but I did want to throw out, we had talked about inviting people who try maybe the declaratory judgment forms or any of the other tools that we offered in this presentation to give us feedback. Let us know if it worked or not. Let us know what we can do to improve it, please.
Yep. Let us know if it worked in your county. Megan has really spearheaded it in the south, the southern part of Minnesota. So
the whole bottom half, northern Iowa.
Have you done it in a number of counties in southern?
Yes.
Okay. So we got some judges that are used to it, but we've got to kind of get it spread out and make it more common statewide because we have to have a solution to this problem. So if you try it, yes, please reach out for help as you're as you're deciding if it's appropriate, as you're filling out the forms, as you're filing them, whatever it is, we want to help. So just feel free to reach out. My information's up there, so is Megan's. Megan's the expert, but I'm sure happy to.
I made this up. I made this whole thing up. It's working, but I made it up. So fake it till you make it, guys.
Okay, I think I don't see any other questions coming in. We really appreciate everyone's time and attention.
100%. Thank you to Standpoint for inviting me today. This was a lot of fun and great to be able to provide hopefully some resources to all of you guys and all the wonderful work you guys do. So thanks, guys.
Absolutely. Yeah, thank you so much, Megan, for your time.
All right.